Good evening. Today I'm going to say something about the law of assignment, both under statute, which operates by virtue of Section 12 of the Conveyancing Act in New South Wales and cognate provisions in every other state, and also by means of an assignment in equity, what we call an equitable assignment. And we're looking here at a means of transferring a shows in action from the assignor to the assignee. Tricky area, of course, and when we start looking at it, we've got to deal with a number of quite interesting and difficult concepts which are absolutely fundamental to our understanding of commercial law. First of all, what is a shows in action? Well, a shows in action, that's law French. A shows is a thing in action is something which is recoverable by means of court action. So a debt, for example, is a very good example of a legal shows in action. Why is it a legal shows in action? Because it's recovered in a court of law. Is there an equitable shows in action? Well, yes, there is. A large number of equitable shows in action. A good example of an equitable shows in action would be a claim in relation to a trust. Why is it equitable? Because it's enforceable in a court of equity. So we're looking here at the assignment of a shows in action, be it legal or equitable. And for many, many centuries, the common law did not really like assignment at all. And the reason it didn't was because of the existence in the very old days of two complementary torts, I suppose one might say, the torts of champerty, champerty, and maintenance, maintenance, champerty and maintenance. What do those torts involve? Well, they are torts which look to prevent any third party from intermeddling or becoming involved in a court case being run between two other parties. So for a long while it was both a tort and in some levels a crime to be involved in assisting someone else to run a court case. And of course you can see in a sense assignment necessarily involves that, because you have the assignor transferring the debt to the assignee and the assignee then suing the debtor. And that's the way an assignment operates. There's a transfer of the legal right to seek recovery of the debt from A to B, the debt being owed by C. So courts of common law didn't like that. There were a number of ways in which the Court of Common Law got round the particular problem, and the key case to look at in that whole area is the famous case of Norman and the Federal Commissioner of Taxation, 1962, 109 Commonwealth Law Reports at page 9, and in particular the important judgment of Sir Victor Windeyer, one of our greatest judges and a tremendous legal historian as well. And in that case, in Norman's case, Sir Victor Windeyer points out that there were a number of exceptions which the common law developed with respect to assignment, or the rule against assignment. One situation was where there might be a power of attorney or an agency given, whereby the assignor would empower the assignee as agent to actually sue for recovery of the debt. Another possibility was with respect to the law of negotiable instruments. Negotiable instrument, a cheque, bill of exchange, is something which, as a means of transferring an obligation in terms of instrument, arises under the law merchant in a rather complicated way, which we don't really need to cover in any more detail today. Look at that in another tutorial, another lecture. Alright, so we've got those possibilities at law, but basically the common law didn't permit assignment. The Court of Equity never had such problems. The Court of Equity from an early stage permitted the assignment of shows in action and will permit the enforcement, applying the usual rule which we've noted before in earlier classes with respect to joinder. And the rule in equity, of course, as we've discussed, is that you must join all necessary parties. So in an assignment situation, the assignor would transfer to the assignee. The assignee could compel the assignor to join with him in suing the debtor for recovery of the funds. End of story, no real problem. So a system of equitable assignments still exists today, and equitable assignments are still very, very important. One reason they're important, as we'll see commercially, is because under an equitable assignment there's no immediate necessity to give notice to the debtor that there's been an assignment of the particular right or shows in action. What about a legal assignment or a statutory assignment? Well, since the Judicature Acts, there has been a means of assigning shows in action by means of the statute. And the statute, which is Section 12 of the Conveyancing Act in New South Wales, similar provisions in every other state, all deriving from the Judicature Acts of 1873 and 1875, permits the assignee to give notice in writing to the debtor or the assignor can do so, saying that the debt has been assigned. And if the debt has been assigned, then that works as an effective method, provided it is writing, to permit the assignee to sue without needing to join the assignor at all. He can sue the debtor directly. The only important point to note there is that any such assignment is subject to equities, and we'll need to come back and look at that. It's subject to any equity which exists in an interim way between the assignor and the debtor himself. Take a simple example. Suppose I have sold you some bricks for $100. Right? So I am owed a debt and I could assign that debt. You, on the other hand, are a debtor. You owe me $100 for the bricks. But it may be that you're unhappy with the bricks. So as between you and me, there is an equity in the broader sense which has arisen because you would, if I sued you for the price of the bricks, be able to come along and offset the price. You'd be able to sue or offset monies for breach of warranty, for example, if the bricks were no good. So that is an equity which exists between me selling the bricks to you and you as the debtor. And if I then assign my debt to someone else, I assign it to Fred. Fred is the assignee. Fred, if there's a legal assignment in writing under section 12, can then proceed, but he takes subject to any equities which existed originally between the original vendor of the bricks and the debtor. So his position can't be any stronger. And that's what we mean when we say that any assignment is subject to equities. Now, it's important to note that although there's a whole range of shows in action, it's still a question whether or not you can assign a purely personal right, a purely personal claim. And a good example of that is a claim where I'm seeking to recover money in tort for some personal injury you have done to me. Suppose, for example, you've bumped into me in your motor car, negligence, I've suffered some injury. Can I assign that personal claim which I've got for damages for personal injury due to negligence to someone else as the assignee? Jury's out on that, but it seems at present you still can't do that. There must be some genuine commercial interest in the taking of the assignment. You can't transfer purely personal claims. And a case that tells us that is Poulton and the Commonwealth in 1953. Poulton's case suggests that there's still that bar. A case which tells us we must have a genuine commercial interest in the transaction is Trentex, Trendtex, Trading Corporation, and Credit Suisse, Credit Suisse, 1982, appeal cases 679. That's the key case in the House of Lords in England, which lays down the fact that provided you have a genuine commercial interest in the transaction, you can transfer. Now you'll see, of course, here, buying and selling debts is a very large business. Also, buying and selling claims is a very large business. But we've got a bit of a problem because, in a sense, a claim may be too small to actually litigate. For example, suppose you bought some shares on the stock market. The price has gone down. The company has failed to give you sufficient information about the problem. So you bought and the market's uninformed. Well, at present in Australia and in the growing way, there are a large number of litigation lenders, people who will fund litigation now on the basis of taking a share of the proceeds of the transaction when you win. Is that valid? Well, in a sense, of course, it runs contrary to the rule against champerty and maintenance because they're going to share, maybe say 30% of the proceeds of recovery. But the High Court of Australia, in a very important case which you must have a look at, called Fostif versus Campbell's Cash and Carry, FOSTIF and Campbell's Cash and Carry, in 2006, by a split decision, held that such a transaction was valid. And if you read the newspapers every week, you'll see that some large company is being sued by a litigation funder who is seeking to recover on behalf of everyone else. And that's tied into the law of champerty and maintenance. Doesn't seem to be such a problem. All right, so we need to look at a number of things. First of all, who is the assignor? The assignor will be the person who is owed the debt by the debtor. Who is the assignee? The assignee will be the person to whom the shows in action is assigned. What exactly is being assigned? Well, in the usual case, it's simply a debt or other legal shows in action. It is possible to assign an equitable shows in action, no problem with that. Can you assign an equitable shows in action under Section 12? Section 12, you recall, was brought in by the Judicature Acts and so represents a change to the existing common law, which I've already told you prevented assignment from operating. Well, it's a funny old section. Section 12 and all the other sections in the other states refers to claims against debtors, etc., and trustees. Now, as soon as you mention the word trustee, you are necessarily talking about an equitable interest. And so in that situation, the interest must be an equitable interest, which is being assigned. One assumes if a trustee is involved, High Court in some dicta, in Everett's case, Everett and the Federal Commission of Taxation, involving a partnership, has held, by way of dicta, that an equitable chosen action can also be assigned under the statute. In other words, you can use writing. Now remember, of course, writing is only required if you're relying on section 12. That's to say the statutory method of assignment. It's important, of course, that the assignment takes effect immediately. Right? If it's an assignment by way of charge or some lesser transfer and not an out-and-out transfer of the interest, then, according to the statute, it will not operate. Does it matter if it's voluntary or for consideration? Well, in the usual case, the transfer by way of assignment will be for consideration. A good example of that is the classical bank loan, where you give a bank a charge or some other equitable assignment or mortgage over your particular property. You go to the bank and you say to them, well, I'd like to get a loan. You say, yes, what security have you got? Well, you say, I've got some real property, so I can give you a mortgage, real property mortgage over the property. I've also got some debt, which is likely to be accrued or which is already accrued. You can take that. Now, provided that you have received consideration for the promise, in the Court of Equity, the Court of Equity will enforce that promise with respect to your undertaking to transfer the debt as and when it comes into existence. So if you think about the usual situation, you've got a number of items, I guess, which are available for security, which on the basis of an assignment of future property will operate as soon as the property comes into existence. To take a simple situation with a small factory, you might have two sorts of future property which are valuable. You might have receivables, that's to say book debt or debts which the company will be owed in due course as you're proceeding. And secondly, you might have inventory which you are going to make. And in relation to that, book debts and inventory, a promise to transfer that for consideration at a future time will be effective as a matter of equity. And that's because of one of the maxims we looked at: equity treats as done that which ought to be done. And the case which illustrates that is a case on our list, re Lind Industrial Finance Syndicate, 1915, 2 Chancery, 345, which is a fairly interesting, funny old case and looks at the question of future property. And in Lind's case, the question was how various assignments operated. Lind was entitled to an interest under his mother's estate at some stage, and under her will, and he mortgaged that interest at some stage. And although it was a future interest, it became transferable because his poor mother became of unsound mind, and therefore she couldn't revoke her will. The will was going to operate. Then Lind becomes bankrupt. Then he gets out of bankruptcy, and then he assigns to a second, or transfers to a second lender, his interest under the estate. And then his mother dies. And the question is, well, has his bankruptcy removed or eliminated the entitlement of the first mortgagee or the first lender? Answer, no, it has not. It's a bit like a floating interest. The interest hadn't yet come into existence because his mother was still alive. The interest only became his when she died, of course, when she passed away under her will. And therefore the interest was I guess like in suspension, if you can put it that way, at the time of the first transaction. It wasn't eliminated by the bankruptcy, and when the second lender came in, that second lender took subject to the first lender. So we've got that particular case, re Lind, which you should look at. Interesting case. Alright, so to summarise, thus far, we've got a situation involving an assignment of a chosen action. A chosen action may be legal or it may be equitable. We can't assign a personal chosen action, which is one where I'm simply going to claim damages for some injury or damage done to me. The jury's out on that. It now seems, because of the case on litigation lending, of which Fostiff and Campbell's Cash and Carry is the main example, 2006, that it is possible to recover a share of the proceeds if you've provided the funding. The High Court has upheld the validity of that sort of agreement, despite the old rules on champerty and maintenance. In equity, prior to the Judicature Act, there was no problem about transferring an interest. At common law you couldn't do so, but that problem has been removed by virtue of the passing of the Judicature Act. And is this an important area of law? Well, it's absolutely fundamental. The buying and selling of debt is of absolutely fundamental importance in the marketplace. book debt is bought and sold all the time. And I mentioned at the beginning there may be a reason for using an equitable assignment. Well, what is that? The reason you might use an equitable assignment is quite simple. Suppose, for example, you've got a credit card debt with lender number X, Bank X. Right, so you owe Bank X some money on the card. Bank X decides to sell or transfer all that debt to Bank Y. As a matter of goodwill, you of course will have been a devoted customer of Bank X for many, many years. So you will not be happy if you suddenly get a notice from Bank Y saying, by the way, don't pay X, pay us because we have taken an assignment of a debt. So as between the two parties, there might be a valid assignment. The only risk which the bank is running is arising if there is a subsequent assignment which looks to override or overreach the first assignment, and that second assignee gives notice to the debtor first. That's pretty complicated. What does that mean? Well, it's what we call the rule in Durl and Hall, D-E-A-R-L-E and Hall in 1828. The rule in Durl and Hall says this: if you have just an equitable assignment, then the first party to give notice, the first assignee to give notice to the relevant debtor will take priority, whatever the actual timing of the assignment. And the giving of notice, of course, is the giving of the notice in writing. You write to them and tell them, don't pay him, pay me. Now you can see you're both a risk there and a benefit. If you don't give notice, well, of course, the first bank will simply collect the money and pass it on to the second bank. They're fully secured, they've got the interest, there's been an assignment, but no one is any the wiser. As a customer, you're not. If, on the other hand, someone else comes in, the bank, which is highly unlikely, of course, but sells the debt again, then the second person gives you notice first, then the rule in Durl Hall will say that that second transferee or second assignee will get priority, even though its assignment comes second in time. Now, some of the cases involve assignments by way of deed. We've got Norman's case, where I've got a transfer by deed. Not such an important area, really. It's irrelevant in terms of a deed because, of course, there's no consideration for the transfer. The deed itself supplies the consideration. Those are all cases involving income splitting, as was Everett's case. In the old days, for tax purposes, people would try and transfer away or gift away interests under shares and the like to other members of the family who would attract a lower marginal tax rate. And you would endeavour to do that, and if you could do that, then the son or daughter, whoever was taking the interest, would pay less tax. As a general matter of principle, most of the time, when we look at these things practically, we are looking at the question of an assignment for value. All right, now that's an introduction to assignment. We'll come back and look at it. It's a very important area, and it's a difficult area, and it's an area where we need to look closely at all the relevant interests. And we'll explore those more in the next video seminar on this topic.